and 6757 are going to actively respond to a media disclosure request made on September 21st in regards to the medical screening examination report and other related documents.
We have Mr. Garza. Do we have some?
Yes. Yeah. Okay. So what's going to happen now is Mr. Garza is going to get 5 minutes.
Under order. I was going to find jurisdiction.
What's going to find jurisdiction?
So moved. Second.
Is that without objection?
Public comment.
Public comment. Okay, do I have any public comment specifically on the jurisdiction of this case? Seeing none, let's continue. Do I have 6? Yes, I do have, for the record, I do have 6. Can I pass that without objection? Okay, so we have jurisdiction in this case. So now what we're going to do is the complainant is going to get 5 minutes, and then the respondent from public health back there, you're going to come up here, and we're going to give you 5 minutes, make your case, and then we're going to discuss it. We're going to go from there. And you will get another 3 minutes at the end, each of you, to conclude your remarks. So, start with the complainant.
Okay, once again, my name is Jason Grant Garza, and I'm here to file this complaint against the Department of Public Health. I was illegally 5150'd at Northern Station, and I requested the medical records from San Francisco General through the Department of Public Health, which is over San Francisco General. Some interesting things that I want to bring up is that I want to prove to you today that the Department of Public Health is a serial violator, that, you know, there is no precedent here at the Ministry of Sunshine, that I have brought them before you guys many times in regard to my own medical records, and that there's never been any precedent set so that they can continue to deny and force complainants to reinvent the wheel. And I have specific examples. So, for example, here is an order of determination in 2002 saying that the Sheriff's Department failed to provide me my medical records. Because in 2002 I had been, I had written to them also. Okay, then there was another violation in 2010 where Mrs. Shields was sent up because I had requested medical records, and of course Mrs. Shields informed the task force that she wouldn't be at the hearing, what happened was that official misconduct was sent up to ethics, and of course ethics did nothing about it. So what we have, and what I'm trying to show, is that it just continues to happen over and over and over again. First of all, my medical records are public documents. Let me read off what I requested and what happened. Okay. Oh, I'm sorry. In addition, also, I want to state that the last time that Mrs. Shields and everything that I had to get my medical records, they had basically stated that I had to sign a HIPAA release form to get those medical records. Okay. Last time they were in, and I believe it was case 11081, where they said I had to sign to receive my medical records. The privacy information person, Mrs. Gleghorn, got up and testified that I had to sign to receive my medical records. I had to sign the HIPAA release form. These are not public documents, is what it stated basically, and I believe that's what Mrs. Shields sent me. I went ahead and wrote her back and said yes, they were, and I informed her that Ms. Gleghorn and the HIPAA expert had gotten up and testified that I had to sign a release form. Then, after it got all waylaid and everything, Mrs. Gleghorn writes me back, and please note right here, I received your email at 4/25/2012. I am aware that you have not followed up on receiving Dr. Pache's multiple offers to provide a copy of the record that you're seeking. I am proposing, as the privacy officer, very, very important, right here, to provide you with your records. I'm sorry, to provide you with your records. I have consulted with the city attorney, who is in agreement that I may provide you with your records directly, without having to sign a HIPAA release form. To which I wrote her back and specifically stated, Ms. Gleghorn, you know, this is like padding the file. Did you send this information to the Sunshine Task Force, where you had gotten up and testified that I did have to sign this HIPAA release form? You know, and I told her, please, I do not want to be provided with something that is not provided by law, or as you put it, an alternative. Naturally, the task force never brought this up because this was during the nuclear winter. You know, the repeat serial violators got to do it all over again. I believe this has also been included in my packet on this case for you guys to have reviewed. Now, this last IDR that I sent in, I was told that they're not public records, once again, and that I would have to sign a HIPAA release form. As a matter of fact, they sent me down to San Francisco General. When I went to San Francisco General, I of course videotaped that. And of course, when I pulled out the law and showed them the law, of course I was only wrong while I was right. So if there's any questions that you want to ask me, I'm more than happy to go. The last quick thing, 14 times you guys have failed when you send stuff up to ethics. I expect this to be another.
Okay, and thank you. Can we now hear from the respondent, please?
Point of order.
Yeah.
Facts and evidence.
Oh, sorry guys. Do we have anybody out there who wants to put any facts and evidence for this complaint? Seeing none, I'm going to ask the respondent to come on up.
Good evening, I'm Dr. Alice Gleghorn, and I'm the privacy officer for the Department of Public Health here. Okay? Actually, I'm the privacy officer for anything that's not a hospital. So there are separate privacy officers for San Francisco General and for the Gleghorn Hospital. Okay? I've been advised that the current complaint is the same as the prior complaint, which was resolved about 2 years ago. Mr. Garza made a public records request for his medical records. He was advised that medical records are not public records. We appeared before the Sunshine Ordinance Task Force, advised him again that these were not public records, and advised him how to obtain his medical records. Typically, anyone who would like to obtain a copy of their medical records is required to go to the facility where they received medical care and file that request with the medical records department. We need to track who's making requests, and if you're requesting to go to somebody else, that needs to be clearly written out. So the typical way to get medical records is to file that form and sign the request. We can make accommodations if people refuse to sign the form. We can document if this is truly the person in front of us. We can document that the request was made and then satisfy the request, noting that refusal was to sign the record. So, but typically people go to the medical records department, file the request, and get their records or arrange to have them sent to another party. Okay? Part of the form that is signed includes the information that the person is to read through and understand. I recognize that if I am disclosing my health information to someone who is not legally required to keep it confidential, it may be redisclosed and may no longer be protected. I bring that up simply because I want to be clear why we don't bring medical records into a public records request. If we were to give records over in this environment, then those records would be part of any future public records requests involving the activities of this group. So that is why we don't disclose private medical records in a public forum. Okay. 2 years ago, the task force made the determination that Mr. Garza could receive his medical records in the normal way, We made arrangements to have those records ready, available for him at the clinic that he had visited. And there were a number of communications advising him that the records were available. All he needed to do was go and pick them up. He never appeared asking for his records at the clinic, and the records were still waiting there when I was advised that this complaint came in. I was not aware that there were any other medical services for him in the past couple of years. I was not aware that anything happened with the police department that then resulted in a medical record. It sounds like perhaps at San Francisco General Hospital. If he wants those medical records, the process would be the same. He would need to go to the medical records department at San Francisco General and make the request for those records, and those records could be obtained. So I don't really have anything further to add. This information is part of the Sunshine Task Force minutes, from what I understand, from 2 years ago, and nothing has really changed. This is essentially the same request that was resolved already.
Okay, do I have any members of the public that would like to introduce facts or evidence in support of our respondent? Seeing none, I'm going to open it up to the task force to concisely discuss with both the, amongst ourselves and ask any questions to the complainant and the respondent. I'm going to start. Dr. Gleghorn, my question's really quick. You're not at the general? You're administrative?
No.
What, are you at Waddell or you're?
No, I'm part of the Department of Public Health Administration. Actually, I have
With
several.
1380?
Yes, I'm at 1380. I have several other roles that don't involve privacy at all. So I'm the county alcohol and drug administrator, and I have other things that I am part of.
I'm just trying to place you.
So I live at 1380
Okay.
Howard.
I'm going to open this up to my nominee.
Mr. Garza, please.
Yeah, don't go far, doctor.
Yes, please.
We've heard that when you made the record request to the health department, you were directed to San Francisco General. Did you go to San Francisco
Yes,
General?
there's plenty of videos on YouTube where I went and asked.
Okay, and what happened when you went to San Francisco General?
I was misquoted the law. I was told I had to sign a HIPAA release form like I was by Ms. Gleghorn here, you know, way back 2 years ago, which she, of course, has conveniently admitted that this happened 2 years ago. And she doesn't speak to the fact that, you know, there's allowances where I don't have to sign. And now let's not forget, she's not the person who's the most knowledgeable here to represent the hospital according to her. She's only here to represent the Department of Public Health and the clinics, not the hospital. So yes, I did go to the hospital. I did ask. I don't have to sign a HIPAA release form. As a matter of fact, I didn't have to sign one back in 2002 when you guys, you know, agreed that, you know, my medical records were public records. But you split off this case to look for a HIPAA expert who never showed up to agree with me that that it was not required.
I have one additional question.
Please.
Why is the Department of Public Health named as a respondent rather than San Francisco General Hospital?
Because the Department of Public Health is over San Francisco General. They run San Francisco General. I sunshine the correct
Thank
person.
you.
I'm sorry, Member Pilko?
So, Ms. Gleghorn? Doctor, excuse me. All right, so you're with CDHS, right?
One of my roles is
Okay.
in
You do all kinds of
privacy.
things. One of the
Yes.
things. Okay.
My privacy role is over everything that's not a hospital.
Got it. Ms. Sarrier apparently sent us a communication. Is she the new PIO that?
She actually is not the new PIO. My understanding is that there's a new PIO in training.
Okay, so she was
Shields retired.
last year.
Yeah.
That
Some
was
point.
a-
I don't
that was a
remember
fun
how many
retirement
months
party,
ago.
though. Remember that.
Okay.
Okay, so Ms. Sarrier is the interim person who's handling.
She is receiving those communications.
Okay. So you said that you're the privacy officer for the clinics, and there are additional individuals for general and Gleghorn.
Yes, yes.
Who is the privacy officer for general?
For general, it's Maggie Rykowski.
Okay. And is Ms. Rykowski, is she under the same privacy understandings that you are?
Absolutely. We have
Okay.
one set of privacy policies that applies across everything that's DPH and that all of our contracts are also need to follow. Although the hospitals might put their logo on a specific document, it's the same set of policies. And the way we handle, the way we notify clients of their privacy rights is through a HIPAA notice of privacy practices that's given to everyone when they come and consent for services, and that's also available online.
Okay. So I think I'm clear on that.
Okay.
So to Mr. Garza, are you familiar with the individual who was mentioned as a general, or have you followed their procedures to obtain your medical records?
And for the second time, I have plenty of videos on YouTube of me going in, speaking with Philip Katzenberger, requesting, my medical records legally the way I'm allowed to. I told him that I had sunshined the Department of Public Health for my medical records. He informed me that I had to sign a HIPAA release form, which was incorrect. I took the HIPAA law with me, pointed it out where it was incorrect, never got a response. Now, mind you, this is something that's very important for you people to look at. Yes, you did. This is what I received on the 14th, which was 2 days past the deadline. Everything was supposed to have been submitted by the 12th. I submitted all my stuff by the 12th. In this, it says that basically the Department of Public Health, his failure to provide information and details that have not already been heard by this meeting group violates the due process of the Department of Public Health. They're trying to say precedent.
Okay, that wasn't my question to you. My question was whether you've gone to SF General and
Yes.
have you obtained?
No, of course not. I've been denied. Of course not, because they're insisting that I have to sign a HIPAA release form, which is exactly what Ms. Claiborne said, which she just admitted that all the policies are the same under the Department of Public Health for the clinics and the hospital. They follow the same procedures, and yet Ms. Gleghorn, in the paperwork I showed you earlier, was willing to make an accommodation.
Right. So are you unwilling to sign the appropriate release to get the documents?
Sir, your phrasing is incorrect. I do not have to sign. They are not the proper documents. HIPAA, PHI was written for my control,
Right.
not their control.
So are you unwilling to sign a release in order to receive the documents?
I do not have to sign a release. Under HIPAA section 1, I have the law right here. So before we go on that wild tangent that you're making, I do not have to sign a HIPAA release. This is what I took in to Philip Katzenberger. This is what I brought to you guys last time. 164-524 says I can request my medical records written or show up and request them orally, and I did write them, through my sunshine request.
Do you have a subsection here?
Yes, 164-524.
Do you have a subsection of 524? The long,
Well, it's probably the very first one, A, B, or C. I mean, it's very implicit. I'm just trying to find where it is because...
we have that in our packet, but it's a rather complicated section of federal regulations.
Right there, it is number, hold on a second. I gotta put my glasses on, I'm an old man. It is number 1, right to access. Except as otherwise provided in paragraph A2 or A3 of this section, an individual has a right of access to inspect and obtain a copy of the protected health information about his individual designated set as long as the protected information is, so there you go. I'm entitled. So, this begs the question as to why Ms. Gleghorn, made this accommodation supposedly, and I said, I'm not going to do this until we go to Sunshine and you explain to them that you lied to them. That's why I didn't go pick up my records. Because this was in 2012, probably while you guys were closed down.
Okay, I think I'm good with that. So,
Thank you.
Dr. Gleghorn, if Mr. Garza is unwilling to sign the requested release, if these were records that you held, you would make a note to the file as you indicated?
Yes,
And
and he's been
close that?
told that.
Okay.
I want to say that this is a very unusual circumstance.
Yes.
Typically, people fill out the request, they're very careful noting what they want included or not, and they sign the form, and that's the document, it goes in the chart. It's extremely rare that someone would make a demand for records and then not write that that is what they want. Because the request is in writing, I was advised by the city attorney that we could go ahead and comply with the request if he came and I documented that he was refusing to sign. They would accept that as
In lieu of the signature?
in lieu of the signature, but it's highly unusual, and I wouldn't be surprised if other medical records departments, and indeed every clinic has their own medical records department, would not respond to that kind of request because it's so atypical and unusual.
Would your colleague, whose name I'm already forgetting, at SF General, apply under these circumstances the same principle, identify Mr. Garza as Mr. Garza, make a note to the file, reference the written request, and disclose the documents? Would that be the normal course of affairs?
Well, no, the privacy officer typically wouldn't be involved at all in this.
Medical records?
It's medical records. You go to medical records, you complete the form, you turn it in, you get your records. And indeed, his records from 2 years ago have been waiting for him at the clinic.
And still are. But the records at issue in this complaint relative to this particular incident,
I wasn't aware there were records at San Francisco General, but we could certainly communicate with medical records if I knew if this was an inpatient, or I have no idea what
as we
What was
heard in your
involved?
case, it sounds like it was.
I didn't really, I thought it was all a police thing. I didn't realize it was involved the hospital at all.
I think as I'm interpreting that it was a 5150 issue that may have resulted in a trip to general, but I don't know that for a fact.
So emergency room or PES or something like that. Okay.
I don't even, what is PES? That was referred
Psych
to?
emergency
Yes,
services.
emergency services.
They would typically
These
hear
say I've never
5150. Yeah.
Involved in
Yeah.
that. Okay.
But, you know, we really would like to accommodate his request. We just haven't had the follow through in the last 2 years for the records that he requested previously. And as I say, I was unaware that there was another admission.
I guess it sounds to me like it's not really a public records issue, it's a medical records issue.
That's right.
It's properly handled under HIPAA pursuant to the regs of DPH.
Anything else? Young lady, you have the mouth agape look.
I have no further questions for either side, so
Okay.
for the moment, I'm good.
Member Sims and David? You're looking, not you, you're looking quiz, I'm looking to the
No,
table.
I'm just trying to clarify whether, because I do agree that it does entail HIPAA, and obviously, I mean, while the Sunshine Ordinance does cover the city, I mean, as we well know, federal law trumps state law, and state ordinances and local ordinances as well. However, the question is whether, to what extent, we are charged with enforcing. But I disagree when it comes to the statement that the issue is solely HIPAA regarding us and public records, because it sounds like it is a type of record. It may not be public per se,
It is a public
but
record.
it is. I mean, it is about access to the record. And he should be getting that access. He's a member of the public, getting access to records that were produced in the public sphere. That makes it a public record. Whether
Correct.
it's exempted from being produced to all to see, it's an exemption, and then he can get it himself.
But if,
You know what I'm saying?
yeah, but if the department explained to the complainant how to receive the records, And they did so on a timely basis.
No, I agree. They did. They did so on a timely basis from I guess the last time he was here. It sounds like this second time regarding SF General Hospital, if we are to believe the circumstances occurred as they occurred, right? Maybe the person in the medical records was not following the policy with releasing the public records without signing the HIPAA declaration. What she has said is basically, I'm sorry, I didn't mean to call you she, Dr.
Okay. Dr. Gleghorn, yeah.
Gleghorn?
Gleghorn.
Gleghorn, okay. Doctor.
Foghorn Leghorn.
What you said is your policy, and I'm not trying to belabor this, but what you said is your policy, so it sounds like there's a lack of policy being funneled down and either written in some type of format for the medical record staff of all the clinics and facilities under the Department of Public Health, right?
All of the clinics follow the same policies, and the typical
But do they,
99% of the cases would be to
Yeah.
fill this out and sign it.
do they know about that
Usually-
1% exception, which is his policy, which is his issue?
No,
That's the
because
issue.
it typically wouldn't be done under normal circumstances. I mean, we only entered into this on the advice of the city attorney following the visit to the Sunshine Task Force.
Yes.
Yeah.
And I think to me, I actually don't even know if this whole incident is itself a violation, or is this something that needs to go to education, outreach, and training or compliance, so that we can make sure that the 1% policy gets out to all of the entities that are under the Department of Public Health.
Well, the policy also includes in training for all DPH staff that if they have any questions or concerns, they're supposed to contact the privacy officer.
Yeah.
So the privacy officers are aware of this and could give the answer if the staff.
If the staff contacts.
I'm just trying to make the point that it is so unusual for anything like this to happen.
Yeah.
I think people, they have their instructions,
They have their
follow their
instructions.
instructions.
I'd just like to bring it to the attention of the task force, page 227 of your packet. There is a italicized and bold portion that actually paraphrases part of HIPAA, and it seems that the policy was actually based on codified federal law, stating that including a signature for the medical records at issue is within the confines of the law.
Third paragraph down.
Okay.
Well, do I have any other comments, questions from the task force? Hearing none, I'm just going to.
Yes, I would like to ask, sorry, Mr. Garza, when you went to General and asked for your records and were told to fill out a form and sign, and you said you didn't have to, what was their response?
The director of HIS, Health Information Systems, Philip Katzenberger, told me I was wrong. One thing I want to point out to you people, this is from Mrs. Shields in 2010, where she states that giving me my medical records without signing HIPAA violates everything. There's no 1% here. There's no nothing here. When Ms. Gleghorn got up here and testified, priorly and everything, she didn't testify that she had sent me the alternative later on and that she had lied to you guys and said that I couldn't receive all these things 2 years ago. She's never caught to that. You've never asked her about that. Right here is a contradiction. This young man just brought up about a signature. Last time we had this discussion, Mr. Nee, 2 years ago, we discussed about the signature on my email IDR and that was a signature. Now they're going to bring up Section 508 about releasing my medical information. Excuse me, Section 508 is to other people, not for releasing the information to myself. The privacy clause is for me. I don't have to be worried about keeping things private for myself. I do not have to sign the HIPAA form. You've been misled, misdirected. Could I answer another question for you, Mr. Oka?
It seems to me that given that Dr. Gleghorn has said that you do not have to sign the form, but, you know, it seems to me that the records are there for you to...
But, sir, this is the first time she said it. 2 years ago, she said I had to sign the form, and then when you guys ended this case and split it off for the HIPAA expert, then she writes me afterwards, in which I wrote to her, no, we've got to go back in front of Sunshine to get this straightened out. Let's not forget this key, important issue. You're being played.
Thank you. Do I have a motion from anyone?
Rebuttals?
Okay, so now we're going to rebuttals, and the respondent is going to go first, and you get 3 minutes for rebuttals or any conclusions or anything else, Dr. Gleghorn, that you want to share with us, and then we will hear from the complainant, who will also get 3 minutes. Rebuttal conclusions.
I'll just summarize that medical records are not public records. They are not releasable through a public records request. They are releasable when you file a specific request for your own medical records. And the form, which is based on federal law, does have a signature. And the typical process is that the form is completed and the client is served. We have, because of the work coming here to the Sunshine Task Force, we have tried to accommodate Mr. Garza's requests. We have offered him to have it available. I have been advised that we can document that he refuses to sign, but we verify that it's him requesting the records. Really asking for a signature is to protect the client and to have a document that shows you made the request. So in waiving that right, we could document that he refused to sign and give him the records. The records are available through the Medical Records Department where service was received, and we're happy to accommodate those requests, and I'm happy to answer any other questions.
Thank you. Okay, so now we'll hear from the complainant, Mr. Garza.
Well, I certainly hope that, you know, if the records are available, that she will be available to explain to Sunshine why she had misled Sunshine 2 years ago. Also, if the records are available, does that mean that I can go down to San Francisco General, not sign anything and pick up my records? I'd like for her to answer that question. You know, what does available mean? You know, priorly, she said that the records had been made available to me, you know, if I would sign the HIPAA release form. Apparently that wasn't correct. So what do her words mean? I truly do not know at this point. I do know that I do not have to sign a HIPAA release form, and that's incorrect. I do know that you've been lied to and misled in the past, and now all of a sudden, you know, there's this gracious allowance on their part, which they've never explained to the Sunshine Task Force why this was allowed to happen in the first place. Now, you know, she gets up here and she says, you know, they're so willing to help me. Well, Jesus, I've got 3 or 4 videos on YouTube of me going to San Francisco General. Apparently I wasn't helped. You know, I've also, you know, got this response to her from 2 years ago, which she's never responded to. The letter that I showed you, asking her to come back in front of Sunshine so that we could clear this HIPAA issue up, she never responded to. In all her glory, as a doctor, to do no harm. I'm being harmed. I'm being lied to. I've been correct all along. You guys in the past have found that yes, one's own medical records are public documents. This is the thing I tell you about precedent. So again, you'll find that they're public documents. Again, you'll find that I'm entitled to them. But there'll be no precedent. You might send them up to ethics, who won't do anything. And then next year when this happens to me, I'll have to reinvent the whole wheel all over again because they'll once again say, guess what, Mr. Garza? Your records aren't public records. It's worked for them in the past. It's worked for the last 10 years, and it's still working. Nobody's asking them the important questions here. Are they public records? Yes. We all know that. Am I entitled to my own private public records? Yes. Did I do everything that was required through Sunshine? Yes. Does this violate HIPAA? No, she just said it didn't because all I had to do, like I've said all along, is request them writtenly, which I did through Sunshine, the Department of Public Health, or show up with my ID and request them, and I did all that. That's all on video on YouTube, So please, please don't disappoint me once again. And make sure that when you make this ruling, that there's a precedent set. So that when anybody in the future asks for their medical records under Sunshine, they won't be denied. Now, someone else's, of course, deny it. But your own medical records, which you have control over, to be denied and to have to sign for? How am I invading my own privacy?
Thank you. Ladies and gentlemen, only of the task force. Well, hearing no motions,
You're kidding me.
bring it home, Liberty.
I am going to make a motion. I'm trying to figure out which specific sections are relevant here. But I think there has been a violation. And the reason I say that is that when someone, when there's a third party involved, all right, if for example, I went to San Francisco General and requested to see the records of Mr. Garza, then they would have to contact Mr. Garza and get him to sign a release form for that to happen. Yes, if Mr. Garza wanted his records sent to a third party, chances are that yes, he would have to sign a release form. This is for his protection and the hospital's protection or the department's protection. But when this is just a two-way transaction, when it's just Mr. Garza asking to see his own records about himself, the task force has held in the past, and I think it's a good interpretation that no signature should be required as long as he can prove his own identity, which he is able to do. Now, another little conundrum here, Mr. Garza has named the Department of Public Health as the respondent because the Department of Public Health is the department with jurisdiction over San Francisco General Hospital. And I have no quarrel with that, but Mr. Garza went to San Francisco General, and that's where he encountered the problem. So I think that even though nobody at San Francisco General is named in this complaint, I think that somebody at San Francisco General needs to be held accountable here, and the person I would guess off the top that would fall to would be Philip Katzenberger, the gentleman whom Mr. Garza identified during his testimony. Accordingly, I move to find Philip Katzenberger of San Francisco General Hospital in violation of Sunshine Ordinance Sections 67.21B and C, and 67.26.
When B is in boy,
B is in boy, 67.21B is in boy, and C, and 67.26.
okay, I'll second that.
We can discuss and then public comment.
I believe that would be at your discretion.
Do I have any brief discussion required before I move to public comment?
Well, I think I've already given, the reasons for my motion. If anybody else on the task force would like to comment, I'm certainly happy to hear.
Member Philpott?
I'm certainly open to public comment, but I think my feeling at this point is that this is not really a public records sunshine issue. It's strictly a matter between Mr. Garza and DPH or SIGN General as relates to his personal medical records, which are subject to DPH's forms and procedures for implementing HIPAA. But I'm open to public comment.
My discretion. And do I have any?
Mr. Oka?
Oh, I'm sorry, Member Oka, do you have something you want to?
Yes. Mr. Kohler,
Yes.
in this particular case, is Mr. Garza's medical record public record?
I think that's for the task force to determine. I mean, I provided you with legal authority. I shoot that back to the task force to interpret that authority and determine whether or not they think these medical records are private or public documents.
But I'm asking you for your opinion.
I'm not here to give opinions, sorry.
Well, I mean, Bruce, my belief is that, and I'm tempted to at least kind of go along with my fellow member here, because I think it is a public record that is exempted from disclosure. Regularly exempted from disclosure in almost, at least in San Francisco. Exempted from disclosure based upon the exemption, the federal law exemptions, as well as the actual Sunshine Ordinance Task Force, the Sunshine Ordinance has the exemptions for this. So, I don't, I mean, I see how there can be improvements in the Department of Public Health to make things clear. And this is no way is saying that, you know, they almost didn't do the right thing here. I think they did the right thing. I think there just could have been an extra maybe little step that could have used improvement. We all need improvement a little bit in life.
Member David?
Yeah, I think what's frustrating me about this case is that, you know, whether, I almost feel like, whether you think that the records are public records or private records, it seems like that there is a very low bar to jump over in order for the complainant to receive them. It's not like that there's a huge, you know, regulatory mess that he has to go wind his way through to go receive these records. And so I'm a little bit, I feel like that this is a little bit of like making an argument for the sake of making an argument as opposed to an actual desire to get one's records. It seems like if one really wants his records, it's a fairly simple, straightforward process to do that. And so that's my frustration, is that it seems like that there's nothing more for us to do. He knows the steps he needs to take to get the records. It's been made very clear. Doesn't seem like it's a big, like I said, a big hurdle to jump over. So that's kind of my frustration with this.
Member Oka?
I'm perfectly willing and ready to find a violation Because even though the person that nominee named at San Francisco General is not named in the complaint, the Department of Public Health is responsible and oversees the whole operation of the health system in San Francisco. So I'm ready to find violation.
Here's the definition of what a public record is.
Yeah, let's get on with it. Yeah, do I have any public comment from the gallery? Seeing none?
No.
You don't see none.
No, I'm gonna
I would give you like the 10 seconds to get up there before I would bang the metaphorical gavel, so go on, Mr. Pedrello.
Thank you very much. I'm once again in opposition to the motion. Medical records are not public records. If they're public records, then they're disclosable to everybody, not just the medical recipient. I like the common sense approach by Mr. Martin. Mr. Garza could have simply signed his name and gotten.
David.
I'm sorry, Mr. David. Excuse me.
Just call you Mark.
I apologize, Mr. David.
I wasn't used to getting a compliment, so I was a little confused.
Shocked me too, I'm like,
I'm complimenting Mr. David.
be the man who might
I don't see any violation. You may be, your motion is requesting San Francisco General Hospital and the Department of Public Health to violate federal HIPAA regulations by finding a sunshine violation tonight. Clearly, Mr. Garza simply just signed his signature to the document that, you know, we all sign when we want our medical records, whether it's from UCSF, Stanford, or San Francisco General Hospital. We sign our name to a document and we get everything we want. So I'm opposing the motion, and hopefully majority of you will also. Thank you.
Thank you. Do I have any other public comment lingering on the sides? Okay, finally, hearing none, I'm going to move on. Mr. Clerk, can you reread the motion for us?
The motion is by Phil Katzenberger of the Department of Public Health in violation of Sunshine Section 67.21B and C and Section 67.26. On that motion,
Was it second? Yeah, second.
Yes, it was seconded.
Okay, I was just making sure.
on that motion, Member Nee.
Yes.
Nee, aye. Member Pilpel.
No.
Pilpel, no. Member Sims.
Aye.
Sims, aye. Member David.
No.
David, no. Member Highland.
No.
Highland, no. Member Oka.
Aye.
Oka, aye. Vice Chair Fisher.
No.
Fisher, no. The motion fails.
Okay.
There being no further motions, the matter is concluded.
Thank you. Can you call the next item, Ms.